Welcome to the People's Law School. My name is John Brinkley and I'm a member of the Alabama Association for Justice. I'd like to give a special thanks to Tommy Battle for allowing us to be here in this building and Judge Sonny Rodenhauser for allowing us to have this courtroom. People's Law School relies on the City of Huntsville and its kindness to allow us to teach. Richard Chesnut is here to talk to us about real estate law. Richard Chesnut is one of the few attorneys here in North Alabama who can not only litigate a case but also handle a transaction. It's interesting to know that this type of knowledge can follow one from the office all the way into the courtroom where many of these real estate issues come to pass. A lot of times these real estate lawyers, they don't do so well in a courtroom, but Richard has tried thousands of cases, I believe, here over his time here in practice in Madison County. He grew up in Cherokee County, Alabama. He went on to Vanderbilt Law School where he was taught engineering, and then he went on to law school at the University of Alabama where he graduated and has come back to come to Huntsville with his wife Betty and practicing law here for 40 years. Yeah. 40 years. I will tell you this, if it were not for the practice of law, Richard would be the best little girls softball coach anyone's ever seen. He's taught both, or coached the ponytails and the ladybugs, I think, on many occasions at Mayfair Park here in the city of Huntsville. We appreciate all he has to do, and I look forward to hearing what he has to say.
Thanks, John. Yeah, that girls softball, that's a tough ticket. And a lot of fun, too. I was listening to Mr. Glover, who was talking about the products liability. And John mentioned it, and I was struck with the difference between the type lawsuit he was talking about and the type lawsuit that comes up a lot of times with real estate. And he said, you know, if you broke your finger, you really couldn't file a lawsuit because of the expense and everything. But, especially in rural areas, I was always told, and I think it to be true, you let somebody move a barbed wire fence 2 feet over to correct what he thinks is an error in a boundary line, and you got yourself a lawsuit. And nothing around here that'll start a lawsuit quicker than somebody over a boundary line between land, or maybe killing a hunting dog, but you get the point. That's, you know, that's the same thing. Now, we're talking about real estate. That's a large, large subject, and I can't cover it all tonight, I'll be honest with you. But I hope it's what I say is interesting. I'm going to invite questions. I hope during the course of the presentation, if you have a question, I'll try to answer it quickly and move on, or we might save it to the end. But real property is dirt. It's soil. It's land. That's what we're talking about. Personal property are the things that you put in your pocket, things you put in your safety deposit box. They're money. They're things. The real estate and what's attached to it are what you put your things in. Now, in theory, the owner of a parcel of real estate owns all the way down and all the way up. Air rights, mineral rights, under the ground, top of the ground, everything. But we're going to talk a little bit about how somehow that can be split up depending on the type ownership you have. Now, what I'd like to do is I'd like to start a few years back in 1066. I'll get here. It won't take me long. When William the Conqueror went across the English Channel and took over England and established the feudal system. And that, of course, was where after he did this, he gave the property there on that island, England, to his loyal lords that helped him, that gave him his army, that supplied his army. And he gave these land grants to them. They became the people in the castles. And they, in turn, gave their property, or pieces of their property, to the folks that did the actual work. Now, these folks that were doing the work, the serfs, I guess we call them now, they got something in return. They got protection. They got land to live on. But they had to pay a servitude. They had to man the armies, provide for the army, the food, everything that went on. So the Lord got something. This was a relationship that went back and forth. But it was based on armies and wars. Now, eventually, what happened was the people that were working the land outnumbered the people who owned the land. You can see this is kind of a big triangle. And things started changing because originally when the Lord, who got the property from the king, gave this to somebody to work it, when that person that was working the land died, it went back to the king. The person couldn't sell it, that was working the land couldn't sell it. He wasn't inheritable. His family didn't get it. Because king and the Lord couldn't be too sure about that second generation if they'd be quite as loyal. So they had to stop it and keep control of the land. Land was indeed power because it funded and what made possible all of the armies to provide protection. But as we'll fast forward a little bit in English history and say that the change came out that allowed land to be inherited if it was given from the Lord to the servant or the owner. And how this was done was it was given in fealty, and that's from fidelity. There was a ceremony. I mean, swore an oath that to be loyal to the king or to his lord. And in that, under those circumstances, the person who was got this property was able to get the property. It was his. He could sell it, and more importantly, his family could inherit it, and it could go down his line. Big change in English real estate law. Now, why is all this? Why am I talking about this? Well, it's because this country was settled by the people who were getting the land, who came from England. This was an English colony. The King of England gave land grants to people in the United States early on in Virginia, when it was early settlements. Y'all know this. But by and large, the people that came over here were the people who were doing the work on the land. They knew the value of property, and that property, ownership of land, was power. They grew up. That was their heritage. A lot more land in the United States than there was in England. But some of the same principles of ownership that were established back in the 1000s and 1200s are still with us today because they go on and because of the way it was established. After the Revolutionary War, of course, the king didn't own the property over here anymore. He went to the United States. And still, though, you had this all-encompassing, not the king, but now the country that owned all the property. I'll say that with the exception of a few things. If you could prove that you got a valid land grant from Britain, England, or Spain, then you owned it. Because down around, there were some of those things that were out there. But by and large, the United States owned all the property. What would happen then is this. The United States, they started selling or giving away their land. You ever been, out in Oklahoma, the land rush? Get there first, stake it out. You got 160 acres, is that what it was? Done different ways. I've got here, and I would pass these around, but they don't smell very good, and I'm not sure they'd stand the passing because these are original land patents from the government. 1845. James K. Polk's signature, I don't know if it's his signature or not. But anyway, he was the president. 160 acres, and this is what the United States would give out to folks who bought the land from the United States. Now, what's curious about this, and you can come up here and look at these if you want, but let me just read to you what it says. It names the guy and describes the land, section, township, and range, how much land. And then it says, the United States of America, in consideration, so forth, have given and granted, and by these presents do give and grant unto the said Elijah Patey this tract of land, to have and to hold the same, together with all the rights, privileges, immunities, and appurtenances of whatever nature thereunto belonging unto Elijah Patey, in witness whereof. Now, those of you that own property, if you got a deed stuck back somewhere, go look at it. You're going to see language very, very similar to that because it's still used that way. It's very formalized. It means certain things. That language does. But that's the point. It's still the same. Now this and that language conveys property in fee simple. And your deed will probably say that. Remember I called it a fealty? The fee, there you go. It came along that way. It's a freehold estate in the land of a superior lord. The lord owns the land, but you've got this freehold estate. I mean, you can do anything you want to with it. And that's what the fee is. That language is carried on. It's a fee simple because there are other types of ownership you can have that is a type of ownership, and I'll tell you a little bit about that in just a minute. But when you own property in fee simple, now the owner is entitled to the entire property with unrestricted power of disposition. You can sell it to anybody, anytime, during his life. And if he dies without a will, then it's going to descend to his heirs. It's a statute in Alabama and all states that say who gets it if you die without a will. That's what fee simple means. And that's generally what deeds will convey and what you want to own. I've heard folks say, you know, well, I own that property, I can do anything I want to on it. We're going to find out in a little while that may not be so, but you're trying to get there, and fee simple is the start. And by the way, I'm not trying to leave. I have to, a little back issue, and I might have to lean on the chair here. As opposed to fee simple, which is total ownership, unrestricted rights, there are there are a lot of partial ownerships. You can have co-tenancy. You can have two people or more owning the same piece of land, A, B, and C. If you do that, then the person who dies owning that inherit his heirs inherit it, not B and C. It would go to his individual heirs. But you can change that by having a joint tenancy with a right of survivorship. Now this is mainly what is done in the case of a married couple, so that the property is owned by both people with an undivided 1/2 interest, and upon the death of the one, the survivor would then own that property automatically by operation of law and in its entirety. It's got the survivorship feature. There's also a thing called a life estate, and that's when somebody will convey property to another party and reserve a life estate. This happens a lot of times in estate planning. You know, I'm getting old, my house is paid for, I don't want it to, I tell you what, I'm going to keep it, I'm going to live here for as long as I live, but I'm going to deed it to you, retain my life estate, and the person who has the property after the life estate ends is called a remainder man. That means neither one of them can do anything with the property without the assent of the other. But that's a partial ownership for both of them. You also have these things, and you've probably heard of them before, they're called fee simple determinable or fee simple with condition or conditional. A lot of times you'll see these in old deeds for a little church out in the country maybe. So okay, I'm going to deed this to this church congregation for so long as it's used as a church, or for so long as it's used as a Baptist church, or something like that. And then you've got a reverter in there that says when it stops, it automatically goes somewhere else, or I will have the option for it to go somewhere else, or my heirs. There's a pretty, and I love this example because it's such a good example of this. Not too long ago, the city of Huntsville purchased the Goldsmith Schiffman field. It's in East Huntsville, an old field that's been there for a long, long time, got a rock wall around it. It's really a pretty rock wall. Well, back in 1934, the Goldsmith and Schiffman families deeded that to the city of Huntsville with this clause: only for the purpose of the athletic field or playground for the use and enjoyment of the students of public schools of Huntsville as an athletic field or playground. In the event, and then it goes on to say, let me get down here, it's got to be kept neat and clean for other purpose. Then the grant, if it's used for any other purpose other than the ones described in this deed, the grantors or their authorized representatives or heirs shall have the right, after giving 60 days notice to the grantee, that's Huntsville, of the violation, to annul this conveyance. So what they did was they gave it to Huntsville and said, okay, you can use it, keep it clean for the athletic, but if you ever use it for something else, we want it back. Well, city of Huntsville wanted to buy it, I guess, and anyway, and because I heard that the Schiffman family, who there's still folks around, were looking all over the world for the heirs. to make sure that they could remove that from that clause and give the city good title of that property because it was still valid. Now, you remember I told you, you own all the way up and all the way down. Of course, you got mineral rights under the ground. Now, I don't know about these, not so much maybe around Huntsville, but in other parts of the world, not so far from here. And mineral rights are a separate and very, very important right to own under the ground. It can be separate and apart from the people who own the surface. People that own the surface have rights if anybody wants to get in there to explore and excavate the minerals, but they cannot prevent somebody from doing it because that is a separate ownership. Air rights, well, I was trying to think of an example on this, didn't have to think too hard. The tram between the hospitals up here off of Governor's Drive, Huntsville Hospital owns most of that land, but I know at least one tract they do not own, and they paid somebody to go over their building and got an easement or right to use the air rights above the building. And of course that is an easement. That's another partial ownership. You can get easements for particular purposes. That's an easement in gross or an easement of pertinent. Now in gross, it would be like I give you the right to come across my land to cut that 40 acres worth of timber over there and back. And once you cut it, you ain't got any rights anymore. Typically, you could charge for that too because somebody's going to make money off of that timber. But it's a limited use of the property. The owner who grants that right is giving up a right. The person who uses it is getting a right, but just a very small part of the total rights in that property. You can also have those easements, and a lot of them are around, that go with land. So pertinent to the land. It's going to be here forever. I'm going to grant it to you. You use it. Everybody else can use it. Huntsville Utilities generally gets that type. Once they get the easement, they can continue to use it. They can also use it for other purposes. That would be cable. That would be telephone. Other part, it's just one easement that helps a lot of folks. You also have other public rights of way or easements. Huntsville Utilities would be a good example of that, but also roadways, highways. Now this gets back and brings up the issue of eminent domain. Now that's kind of harkens back to what we were talking about, the feudal times and the times when the United States owned all the property, and now the state of Alabama would own the property here in Alabama. State owns it. Everybody got the right to use it under the patent or the deeds or however they acquired title. But if the state or United States wants it back, they got a right to get it back. And you can't stop them. I mean, they'd have that right. But they have to pay you for it. They can't just come and take. Now that's where an awful lot of litigation arises. What is the fair market value? What is the highest and best use? How are you going to value the taking of somebody's land? A lot of different things to think about in doing that. One of the things that's come up here recently that I've noticed is that the taking typically by a municipality or any other entity that has the right of eminent domain, and that would include TVA, Huntsville Utilities, Alabama Power Company, any number of universities, Alabama, University of Alabama, Auburn University, has to come by the statute, but these entities also have the right of eminent domain. But it has to be for taken, the land has to be taken for a public purpose. A road. We need the road, it's overcrowded, they're trying to widen Highway 72, that's a good example. They want, well, we got tax problems on that, don't we? I forgot about that. Anyway. No, whole other issue. Whole other issue, don't get me started. But sooner or later, that'll be widened, but that's an example. They're going to go down, take a little sliver of land, make another lane of traffic or two. But there have been some cases, and this was a Supreme Court case, it went up to Supreme Court, that where I believe it was Baltimore wanted to condemn some old, decrepit, run-down, slum-type property on the riverfront. and turn it into a brand spanking new area. Shopping, you know, what we use around here, multi-use. Here we go, shopping, restaurants, lofts, everything, you know, same thing we got going in Huntsville, everywhere. Then the public use was, well, what this will be is, think of the tax revenue we'll get when this happens, and what we won't have to spend on keeping up or maintaining or trying to keep this from killing people and all the liability. Don't know that was, I haven't followed up on that, but I think it passed. I think they granted it. I think it went through. I don't think that's right. And I think Alabama rejected an argument similar to that, the Alabama Supreme Court, probably on some technicality, but that's a use, an idea of, well, they're straining to find a public use. Might have been a good thing, might have been the very thing that needed to happen. But I don't think that that's exactly what the concept of eminent domain was designed to handle. There might have been another way to do it. But let me, one other thing I want to talk about here. I told John we might just start talking about anecdotes here, just playing. Another, and it is a property, right, because it limits the owner's use of the property, and that's zoning and restrictions on the property. If you live in a subdivision, the subdivision probably has blanket restrictions that cover all the lots in that subdivision. Probably residential use only, restricting the size of the building, where it's located on the lot, size of the lot, various other restrictions in there. Those limit you. Zoning, of course, is imposed by the city. It'll restrict you to a certain type of house.
Now, I'm not making this up. These are testimonies from former directors.
You can set the house, or the use. Can it be used for restriction? Can it be used for a movie theater? Can it be used for a school? What about a church? What about all these things? Well, we don't have it zoned for a church, but can a church be here? Probably so, if it's 1B or 1A. Churches can go a lot of places. On the other hand, lounges cannot. They're very restricted. So that's a limitation of what you can do with your property. And I've heard folks say that, again, getting back to, well, don't like folks telling me what I can do with my property. Well, you better think about that. I have seen cases out in the county where, especially in a newly developed area, where you would have a lakefront home, very, very nice, landscape on nice water with nice trees, and not 50 feet from it was a turquoise trailer. It looked like a refrigerator on wheels. Now, there's nothing wrong with either one of those, by the way, but you probably don't want them in the same place. And certainly the folks that had spent an awful lot of money building a really, really nice house were not anticipating this type of use on the property just down the street from them. Not that it's wrong, but it's just, it just doesn't go together. Let me, I've kind of blown through all these types of ownership, but let me see if I can give you an example maybe that kind of will help you. Oh, I'm sorry.
No problem. Let's say that trailer had been there for 6 years prior to the building of the house. Would it be grandfathered in the situation?
Well, you don't really have any zoning. You don't have anything. It's just out there. There's nobody can tell you what you can build. So, I mean, they can do anything they want. They can do anything they want to with it. And if it had been there, somebody building the house, it might have been something they would consider, and they have to kind of take it the way they got it. But I was using an example there where there were no restrictions or no zoning, and you could do anything you wanted to.
Well, someone just asked me yesterday about a situation off of Governor's Drive in a subdivision on the other side. Someone built a new house there and complained because the next door neighbor had a metal carport and a building out back. Mm-hmm. And the metal carport's been there for 6 years. Mm-hmm. You really can't say anything.
Well, if the metal carport is otherwise allowed by zoning and restrictions and everything else, no, it's as legal as anything. I'm sorry, we had a question about if there was the trailer in my example. I'm sorry about that. I should know. The trailer had been there first with the guy in the house have a complaint. Well, the situation there would be that there are no restrictions or zoning to prevent either one of them. So everybody would have the same right to be there. I mean, you know, how are you going to complain?
Could you compare eminent domain with adverse possession?
Eminent domain to adverse possession. Let me get to adverse possession in just a little bit because they are completely different. Okay? I will do that. I want to cover that.
I was thinking about that when you talked about the Schiffman case. I was wondering if once they can't find the owners, previous owners or heirs, and since the state was paying, or the city is paying the taxes on it, would they be able to lay claim to it?
No. I'll tell you why. I'm sorry, but that's a good question. But they cannot because the city got there under permission. They weren't adversely holding anything. They were there with everybody's knowledge, everybody's permission, and under a color of title that just limited their use. So it wouldn't be an adverse possession. Now, well, we'll talk about that. That's a good question. Let me give you an example about all these ownership rights, and let's see if we can kind of do something. Now, I'm going to give you an example of that. I'll use you buying a piece of property out on County Line Road, let's say, from a farmer, and it's you're buying like a 5-acre tract of land, and you know it's at a busy intersection, and the city wants to come in and put the road in. So here they come, and they put in a road. And you know, just like we talked about, it might have been eminent domain. You might have given them a deed, but they put the road right alongside and take part of your land for the road. And then alongside that road, the utilities come in. They want a deed to provide water, electricity, all the utilities. So you negotiate with them and you give them the right, usually beside the road, about a 10-foot UND easement, let's say, next to the road. Then after you hold it for a few years, you say, okay, let's use this property. All this traffic coming up. And you go up and build a little strip mall. Got some shops in there. And you go and you get yourself a tattoo parlor, a Mexican restaurant, and a beauty supply outfit, and you put them in there. And you sign leases with them. And they're going on. And you're collecting rent right and left. Then, a few years later, somebody says, you need to plan for the future, and you start getting scared like all of us old folks do, and you decide, well, I'm going to convey this to my grandchildren, and you do that deed and reserve a life estate. Meaning, you can still get the rent off that thing, but when you die, your grandchildren get it. Now, you got one piece of property. It's that 5 acres. But let's see if we can figure out how many entities have a right to that. Well, first, I didn't mention this. When you bought it, the farmer was convinced there was oil and gas under there, so he kept the mineral rights. Okay? So the farmer kept the mineral rights. You got the surface. The county got the road. Utilities got their easement. You subdivided it, but you gave 3 people a lease on that property. They got a right under those leases to use it. And then you gave your grandchildren the right of reverse and kept your life estate. Now we're talking about one piece of property, but you see how many folks got interest in that? Now granted, it's not the whole thing, but everybody's got some interest in a part or some use of that property. That's what back in law school they used to call the bundle of sticks. I never understood that. But now I got it. You know, you want to hold as many sticks, and every time you give a right away, you lose a stick. Okay, all right. Yes, ma'am.
You do that deeding with your children and you go into a nursing home. Does that count towards your nursing home?
Does the life estate count toward your nursing home
To get Medicaid?
Yeah. I'm going to have to defer that to somebody else. I'm sorry. I'm not sure enough to give you an opinion on that. But I know it's done an awful lot. I do know that. Now, I want to talk about, now we've talked about all this different ownership that you can have, some of the instruments that you might run across in establishing that ownership. And probably a lot of you have seen a lot of these. The first I'm going to talk about is a contract. Now, under Alabama law, in order to be enforceable against the other party, an agreement involving real estate, to purchase or sell real estate, must be in writing, period, no handshakes. I will say real quick though, I understand an awful lot of property has been, is, and will be sold by agreement without contract. But if you, as a seller or a buyer, want to enforce the terms of what you think is that contract, it's got to be in writing, or it's not enforceable. Let me give you an example. Let's say that, let's talk about that 5 acres at that intersection, and you decide instead of developing it, you want to sell it. And you're out there and it's busy and there's dump trucks going by and you're talking to a guy that's going to buy it. And he wants to know how much you want for it, and you're trying to figure out, and you say $3,000 an acre. Well, about the time you said that, big truck came by and backfired, and all he heard was $3,000. He thought that was a deal. So you come to closing, and he hands you a check for $3,000, and you say, where's the rest of my money? Unless you got a contract, you don't have a deal. Because if you wrote it down, somebody's going to say, wait a minute, this says $3,000, not $3,000 an acre. And then you get all the terms right. As long as you agree on it, it's going to happen. But if there's a dispute, you can't enforce a deal that's not in writing if it has to do with real estate. Now, a contract, got to describe what you're selling it for, describe the land, it has to be signed by the parties, everybody's got to agree, got to have it there. It can have an awful lot of other stuff in it. It can have, and probably will have these days, warranties of title, merchantability. I'm going to give you title of this land as a seller by a warranty deed, which we're going to talk about in a minute, guaranteed you passing marketable title. But let me just real quick slide over and recall what I said about real estate being the dirt. Well, does that mean the house that's on the dirt too? Does it mean the things that are in the house that's on the dirt that you're buying? Or not? Well, it may or it may not. I've had, and I've heard, and I've had a little bit of experience like this where folks would sell a house, come to closing, people would buy the house, go to the house they just bought, and the folks that were leaving, the sellers had taken all the light bulbs with them. You know, you just think about it. Okay, you go after the closing, you go, and that nice chandelier that was hanging in the foyer, it's gone. Where'd it go? What about all those expensive window treatments that were there? Now I got up something that looks like shower curtains, and you know, where were they? Wasn't that supposed to go? This is a problem. If that's why you need a contract. You say, this is what goes, this is what stays. If you're buying it, you want that to stay, say, I want this to stay. What about the appliances? Stoves, water heaters, jacuzzis, whatever else is in there. You need to say, if it's something that makes a difference in the deal, it needs to be in the contract. And while we're on it, what are we going to do about mobile homes? Are they attached to the ground or not? Do they go along with the land? If you buy a lot with a very, very nice mobile home on it, let's say on the lake, you don't live like, it's a nice mobile home. We're going to go out there. We're going to use it for our lake house. We're going to go fishing. We're going to go skiing. And you go out there on the weekend after you bought it and it's gone. Well, didn't that go with the land? Was it attached to? If it's attached to the land, if it is attached to the land, it's a fixture. And it does go with the land. A house is a good example. When it says appurtenances in here and you say that's an appurtenance. It is a fixture. Yeah, it goes. It's attached to the land. But anything else that you can remove without causing damage to that house or to the land may not be a fixture. Air conditioners? What about window units? Well, I just shut the window. It didn't cause any harm. That wasn't a fixture. Well, you probably thought if you bought the house it was going to have air conditioners in it. This is stuff that comes up and can be handled by a contract. I don't know the answer to the mobile home question. Well, I kind of do. It depends on how well it's attached. Does it have wheels, or are they going to take it off? I mean, really, does it have utilities run to it? I mean, is it how much does it resemble a residence? that's there permanently and not something that you can hook to a large pickup and drag off overnight. So you know, it's that's a curious, but especially with mobile homes, things like that. If you're buying, make sure it goes. There may be an extra charge for it. Mobile homes, you don't see them up in the record room. They're put on after you buy the land. Now then, we talked about the contract. I'm going to speed up a little bit because I want to get to adverse possession, a couple other things. The deeds that you get, there's several kinds. The warranty deed is the main one. The warranty deed has warranties in it. It has covenant of season. If he doesn't own, that means he owns what he says he owns. You got the right to convey it. He promises that he does have title and the right to convey it. Covenant against encumbrances. There'll be some exceptions there. It says nobody else owns any part of this, no other liens or encumbrances, it generally says, except, generally speaking, zoning restrictions, which you got no, covenants, easements, and covenants of record, and any easements, covenants of record and restrictions and easements that are there. And you see them, these are all part of the title. And the warranty of title is what makes it a warranty deed. When the seller says, I'll warrant and defend the title, it's his guarantee that you're getting good title. If somebody, after you buy the property and you've got this warranty deed, comes in and says, oh, well, by the way, I own about this much of this land over here and that's not yours. Well, you've got a deed to it where your seller says you do own it and he's guaranteed the title. So the next thing you do is go to your deed and say, take care of this. You know, he gets involved in it. That's a warranty deed. And it's what you want. It's what people look for. A lot of times you can't get it. A lot of times you have to make do with a quitclaim deed. Now, a quitclaim deed is just the opposite of a warranty deed. It doesn't guarantee anything. I could give you a quitclaim deed to this building. I don't own it, but if I do own any part of it, I'm giving it to you. And you can pay whatever you want for it, you know. That's an exaggeration, of course, but that's what it is. It comes out where title might be in doubt. A lot of times it comes out where, well, you might have inherited part of this property from your long-lost great-grandfather that you never heard of. We're trying to clear up the title. How about giving us a quitclaim deed? Okay. I don't think I do, but here, if it helps you, fine. Might get a little money for it. But usually it's not worth that much. No warranties at all to it. There's another kind of deed. It's called a statutory warranty deed. And it kind of falls somewhere in the middle of those two. You use this, banks use this a lot, and a lot out of personal representatives that come in that are selling property out of the state. If a bank has acquired property through foreclosure, they'll typically use this. What it says is, we will grant, bargain, and sell this property to you, but we're passing our state in fee simple, but we're not going to guarantee you anything before we got it. That means that personal representative, he doesn't know what the deceased person has done in his lifetime or what liens or claims may come about. But he can tell you, as long as I've been personal representative, it's okay. It's a little bit better than a quitclaim deed, not as good as a warranty deed. And banks typically use it because they don't want to be hung for anything that happened before they got their mortgage, for instance, if they foreclosed on the mortgage. It's just whatever title they got. I want to get to adverse possession. Let's talk about it now. This is how you get property by deed. You can also get it by inheritance. I mentioned that. But adverse possession is something that comes up an awful lot. Alabama's got two adverse possession statutes. One of them is the squatter's rights. Is you stay on a piece of property and you've got to stay 20 years. And I'm looking for my list here. I've got it here somewhere. But just staying there doesn't do it. Your possession of that property, open, notorious, adverse, exclusive, and continuous. I think I got them all. You can't come and go. You can't do it with somebody else. It's got to be open. You can't be hiding. You can't be just going down there at night, and trying to slip around. Notorious means it's adverse. I mean, it's something that would indicate that you are acting like the owner of the property. And adverse would be adverse to somebody who is the real owner of the property. Let me see if I can think of an example. One example would be, let's just use open land because that's hardest. Cutting timber. It's not my land, but I'm cutting timber and I replant it. That's obviously open. I mean, that's all of those. And I do this continually. I harvest that timber and I'm staying there and I've done it for 20 years. And then somebody comes down and says, wait a minute, that's my property. I might have a real good chance of setting up adverse possession on that. The other adverse possession statute allows you to claim adverse possession on a piece of property and full ownership of that property if you have possessed it under color of title and paid taxes on it for 10 years. That's probably what you've heard about. Color of title means anything. A quitclaim deed is a good example. Your name in a will from somebody who might have owned something. I mean, it can literally mean anything, but it's got to have something that leads somebody to believe you might have title and pay taxes. But not just that. It's still got to be open, notorious, exclusive, and continuous. You still got to meet all those. You just have to do it for a shorter period of time. And you got a color of title there. Now, who decides all this? Not me, not the lawyer, not the closing attorney, not you, the guy who's trying to set it up. It's got to be a judge. It ain't adverse possession till a judge says it's adverse possession. Now, a lot of folks will put, and you see it, well, it's mine now, I've paid taxes on it for 10 years and done it. Well, maybe not. Judge has got to agree with you. Your opinion counts, but not near as much as a judge's decision, because you got to have that decree. A judge and his decree takes the place of that deed that you didn't get and relied on your possession and all these other factors to supply. Adverse possession is defeated if you are not meeting all those conditions. So in the case of the city of Huntsville, they got color of title, but it's not adverse. They had the right to do what they're doing. It's not adverse to anything in that deed. They gave them that right. So it's not adverse to the remainder. And it's under permission, essentially. That's under a license. If you are there on that land under a license, if somebody has said, and this is what happens an awful lot. Consider a subdivision. We talked about cutting timber. Let's bring it down a little bit. Let's talk about 2 lots in a subdivision. Somebody put his fence 8 inches over on your property. Now, what does that mean? Is he going to adversely possess it after 20 years? I mean, he's mowing that little strip. Well, but you're paying taxes. But he's mowing it, and he's acting like it's his, and he's put that fence up, and, you know, it goes on there. Is it adverse to you? Well, maybe not. I mean, it's not really keeping you from doing anything to it. But what can happen if somebody surveys it and you start to sell it, and somebody will say, "Oh, good Lord, I can't buy it because his fence is 8 inches over on my property, and I'm not going to do that." Well, you can tear it down and go to a lot of expense and cause a fight, or you can say, "Tell you what, I'm going to give you a license." The guy that owns the fence, I'll give you permission to leave that fence there, and now you have it under a license, my agreement. But if I ever or anybody else ever ask you to move it, you got to do that. May never ever ask you to move it because it looks good and it's not bothering us, and you may be there. But if it bothers somebody so much that they're not going to buy that property, you've got it under a license. You can't claim adverse possession. Guess what? You're going to have to move it. A lot of that happens.
But what about the kids crossing your property and they've worn a path? Can you put a fence up and block them from crossing your property?
Sure you can. Sure you can. You know, you have, you know, your property is your property, and if they're doing that, essentially they're trespassing. Now, you can get an easement by prescription. 20 years adverse. I mean, do it all. You know, do all that. Yeah, you can get that. You know, a road, an access to somebody's property. But if they're just cutting across your property, and you know what's going to happen. They're going to walk to elementary school, then they're going to ride their bikes to mid school, And then they're going to ride their motorcycles to high school. And then when they flunk out, they're going to ride their four-wheelers across your land. And you're just going to run it. So you got to stop it sometime, you know. But no, you can't. You can't. Yes, sir.
You own a house on a curb, and the phone company, when they run their underground cable, instead of following the right-of-way around with the within the 9 feet of the curb, right, they cut directly across your property, and you don't find out about it for a year or two.
I don't think they can do that. I think they're going to have to make arrangements with you if there's not something already there allowing them to put their facilities across your property, some easement or something that's been negotiated. Then that's got to be dealt with.
Been a year because they drill underground now,
Oh, yeah.
and you have nowhere to know.
You didn't know about it. It's kind of like a double secret probation or something. Well, you know, I mean, you could understand if something went wrong with that line, and they came in and had to start replacing it and digging up the top of your, you know, getting down there to it or messing with it, I think you'd have a serious issue with them. I really do. Yes, sir. I'm sorry, I'll do the questions.
How do you go about upgrading a quitclaim deed to a warranty deed?
How do you update a quitclaim deed to a warranty deed? You got to get the people that'll agree to give you a warranty deed and get it from them. You just got to get another deed. I mean, it's not an automatic thing. You know, the people that gave you the quitclaim deed or somebody else who has better title, then, you know, can give you a warranty deed. But you have to get it from somebody.
So if nobody has a better title,
You're okay. Yeah.
quitclaim deed.
Right. If nobody's got a better title, you're okay. Yeah. Yes, sir.
Does a warranty deed require a title search back so far?
Does a warranty deed require a title search back so far?
And how long?
It does not require one. But if you're going to be signing one, you would probably want to get it. And if you were buying property, yes, you do want to know what's going on. You do want to know the chain of title. And that's what we call it. We go back. Now, how long? In this area, 40 years is generally what we go by as a standard. Why? That's 2 adverse possession periods. And 20 years is a statute of repose. After 20 years, a lot of things that could happen will not happen anymore. So that's why we do it. But the answer to your question is yes. If you're going to give a warranty, I would think you would want to do that. It would be worth it. Yes?
Would you explain the difference between title insurance and a title search? What each one does and when you need one or the other?
Okay. I'm about to run out of time, but let me see. We're going to explain the difference between a title search and title insurance. Okay. The quick answer to that is you've got to do a title search to get a policy of title insurance. A title search is the actual activity of going up and looking at each deed. Let me kind of really quickly if I was going to do that. I get the name of the current owner, and then I'd go back and find that deed into that current owner. And then I'd go back and find the deed into that owner I just found. And then I'd find the deed into every owner, and it makes a chain. And then I'd start up and say, okay, did this guy sell it? Did this guy sell it? Did this guy sell it? You run it up. See what all they did while they had it. So I get the people all the way back, and I start back here and start running what mortgages did he put on? What liens did he have? Did he sell it to somebody else? Did he put an easement on it? Is anything going on here? And the same all the way up, so that finally, hopefully, when you get up to the current owner, everything that's happened in the course of that ownership, however far back I checked, has been resolved. All the liens have been paid, all the mortgages have been paid or released, or at least I know what's got to be paid off and released. There's no other deeds have been given to anybody else, no other conveyances to somebody who's outside the chain out here that's hanging around waiting to cause me problems. So you do that. And then you go and you issue a policy of insurance, which is title insurance. And that's all it is. 2 types of title insurance. You can get it as an owner or the buyer, who will be the owner, and a lender. A lender will generally require it up to the amount of their loan. And what that title insurance says, and it's backwards from any other insurance you've ever seen, the title insurance will say, we're going to guarantee you that all this stuff that didn't happen, didn't happen. That's what it does. You know, you get your accident insurance, they say, okay, we'll pay you if you have an accident in the future. What this says is, title insurance says, we'll pay you if nothing happened in the past. Well, you can see what happened in the past. I'm making a little bit of a joke about that because there are some things that title insurance will cover that won't show up in the record. For instance, if one of those people back there, one of these owners, happened to be non-compos mentis, doesn't show up, I didn't know it. You know, wasn't showing up in here. He went ahead and signed his deed. Somebody down the road came back and said, that guy was in, a hospital, mental hospital. He couldn't validly convey title. How was I supposed to know? I saw a signature, saw it was his, saw it was notarized. Title insurance will cover stuff like that you can't see on the record. So it's not just guaranteeing what didn't happen. There's more to it than that. Lender, as an owner, you get that insurance insuring your title to the property. The lender insures their obligation under any loan that they've made for a mortgage to buy the property. They are just like any other title insurance. It is two different policies. It is two different beneficiaries. They overlap an awful lot, but it is not the same coverage. It is not the same. Am I out of time? Is that it? 7 minutes. Let me do this. I'm going to talk to you really quick about warranties on a new home and an old home. This is a lot of litigation comes up about this. This is not ownership now. I'm getting off a little bit. And you heard about products liability and things. Now, in Alabama, the rule of caveat emptor applies to the purchase of a used residence. If you're buying a residence that is not from the builder, it is buyer beware, period. The language is really, really strong. You can have a contract and everybody says, I bought this house. I didn't know, and there's a case here, that the backyard flooded regularly. And you know what? The seller doesn't have to tell you. The seller is under no obligation to point out or explain to you any defects that are in a used residence, unless that defect materially affects the health and welfare of the resident, or the prospective purchaser, asks specifically about it. So you as a purchaser don't ask about flooding. They're not going to have to tell you anything about flooding. Doesn't matter. Also, cases, let's say you did ask about flooding. There's a case here that said they asked about a lake. They went out there and was buying this property and the lake was low. Said, why is that lake low? Is there something wrong with the lake? I said, no, it's been a drought. It's been a lot of... Turns out that lake had been leaking and they knew it and they tried to fix it and couldn't. They lied. So later on, after the lake kept going dry, the people that bought it says, man, that's fraud. I asked you about that, and you told me wrong. You're supposed to... But in their deed, their contract, remember we talked to you about contracts? How it's not enforceable unless it's in writing? The contract he signed said, buyer has not relied on any representations made by the seller or his agent. He has made inspections, and the property is sold as is. Guess what? Contract is what counts. Not what somebody told you. The contract is what counts. Now, so I'll just tell you, let that be. If it does, there's one case where a realtor had, it's kind of not funny, realtor had this house trying to sell it, and the contract said, they already had the contract, and the contract warranted that the furnace would be in working condition. A lot of them say that. That's one warranty that's in there. Well, she had it inspected, wasn't in working condition. Well, they got it in working condition. They said, man, this place, it is a death trap. He said, well, is it working? They said, yeah. I said, okay. Then the purchasers found out that, yeah, it was a death trap. She was under an obligation, the agent was under an obligation to disclose that because health and safety, clearly. Can't do that. Can't do that. There's a lot of strange things that go on like that. Does not apply to a new residence. If you buy a new residence from a builder, that it does go and have the implied warranty of habitability. It means more than you can just live there and get in and out of the road. It means you can live there comfortably. Now, what all it means and what all of the details are, it is a warranty that is involved in products liability. But now you can disclaim that warranty, and builders routinely do in their contract. They will say, and they will tell you, that this house is sold to you without any warranties of merchantability, habitability, or fitness for a particular purpose, either expressed or implied. Everything is waived. There are none.
You said habitability. Don't they have to have a certificate of occupancy?
Got a certificate of occupancy. Yes, sir. To sell it, they sure do.
Habitability?
Habitability, in the legal sense, is more than just living there. It's living there without having the roof leak every time it rains. It's living there without having to, worry about where you put your furniture because the floor is going to fall in. Now, you can get a certificate of occupancy like that, with it like that, because that may come later. But that's the two things I wanted to give to you. You buy a used residence, be careful what's in your contract. Put the items in there that you're asking about. Usually, if a builder does limit those warranties, he will give you a 1-year builder's warranty.
What's your opinion on home inspectors?
Glad you asked that. I was going to say that, and I'm going to say, you get these contracts, especially for used residences, subject to a home inspection. I had one, no lie. It said subject to a satisfactory home inspection. Well, the home inspector came back, had all these things wrong with it. Called the seller, and we said, well, it was subject to a home inspection. They said, would you get a home inspection? Yeah. You satisfied with it? Yeah, it did a pretty good job. Okay, let's go. It didn't say what was going to happen if you found out anything is wrong. It just says subject to a satisfactory home inspection. You see? So you got to go a little bit further. Say, and if anything is found that I don't like, I got to get out of this contract. I get that option. I think it's a good thing. I think that as a purchaser and a buyer, you have to view it with a grain of salt and see, because an inspector will justify their fee and their existence. I don't blame them. It's a good thing to have, but you've got to be ready to negotiate a little bit after you get that. I'm getting the wind-up time, so I'm going to wind up. I've enjoyed talking to y'all. Y'all have asked some good questions.